Hello and welcome to Buy the Book. I'm your host, Joe Hebert, and today we have a special edition of Buy the Book. We have a guest joining us here, Carson Holloway. Carson is professor and chair of political science at the University of Nebraska, Omaha. He has many other credentials, which I'm not going to list because then we wouldn't have time for a discussion. But Carson is the author and editor of many different books. Um, there's one in particular that we want to talk about today, his latest book. And I'm going to put a picture of this on the screen later so you can see the beautiful cover. It's called No Liberty to Libel, the constitutional case against New York Times versus Sullivan. And it also says there on the cover, originalist case for rejecting the actual malice test. So if any of that sounds, obscure to any of the listeners out there, we're going to walk through this and see what this is all about. So Carson, welcome to the podcast.
Thanks, Joe, for having me. I really appreciate it.
It's my pleasure and privilege to have you here. So I wanted to start with just asking you, when you wrote this book and now that it's out, what is your intended audience for this book?
That's an interesting question. And I would say I have a twofold answer to that question. Um, on the one hand, it is a book by a commercial press, published by a commercial press. Encounter Books, as you mentioned, they did a beautiful job with the physical version of the book. So it is addressed to an informed audience of laypersons who are interested in American constitutional law and contemporary constitutional problems. I consider it a work of my own scholarship in American constitutionalism, but it is addressed to that broader audience of people who take an interest in these kinds of things. And I think there are more and more of them because New York Times versus Sullivan has become more controversial in recent years, as we may talk about later. Whereas prior to that, to the extent that it was known, and it was pretty well known, it was taken kind of uncritically as a landmark and therefore correct ruling on the meaning of the First Amendment. So I'm aiming at a broad audience of informed citizens and voters and thinkers who are interested in this question of how to properly understand freedom of speech and of the press. But I said it's a two-part question, or I have a two-part answer. I have to admit that, in a way, in my own mind, the book is addressed to the conservative justices of the Supreme Court to see if they could be persuaded by this argument, because we now have a situation where you do have you quote unquote conservative majority on the Supreme Court, or maybe be more proper to say an originalist majority on the Supreme Court. And when they make their statements in favor of originalism or the quest for the original meaning of the Constitution as the proper approach to constitutional interpretation, they don't really qualify that. They make it sound like that's the correct approach, period. And so the challenge I'm trying to present in this book is to say to them, hypothetically, if they're listening, if that's what you think, you would really have to reconsider the court's approach to this question of libel in the First Amendment and reconsider New York Times versus Sullivan. And there are a couple of justices on the court who have already suggested that, notably Justice Thomas and Gorsuch. And in a denial of certiorari case or opinion just this summer, they did unite one more time and offer a very brief joint opinion saying that they think the actual malice standard is incorrect and deserves to be reconsidered. So that's two. You would need two more to get a grant of certiorari on this question. Then, of course, five to change the court's interpretation. So those are the two audiences that I'm interested in.
Okay, excellent. So you're aiming high there.
Yeah.
Yeah, and I definitely had that feeling in reading this. For both of those, I could check out. I'm also a political scientist who teaches, constitutional law. So for me, I was very impressed with this as what I might call sort of a case study in constitutional law. That you're looking literally at one case, but then from there you're branching out into all of the relevant history and background, as well as then going forward, all the consequences of this case and you're
Mhm.
tying all that together. And I will say that you do that in a way that is very clear and very accessible, I would say to it's very thorough, very, intense, but also I don't see you talking about anything without really explaining it and defining it and spelling things out. So I would definitely concur that this is something that, to the audience, if you're interested in your constitutional rights, if you're interested in the Constitution, what kind of government it's meant to set up and how that's supposed to work as we go through the challenges of modern life, then this is an excellent book for sort of delving because you're picking one particular case, you're going into great depth and detail about all the different pieces that have to be considered in assessing a case like that. And as far as the Court, I definitely had that feeling like I wasn't going to put you on the spot and say, did you, through any back channels, did you get any kind of feedback from the Supreme Court on this? But it does seem like this is the timing is also ideal for this book in terms of the jurisprudence and the indications that we've had from the court about how they're thinking and rethinking some different things as they go along. So a lot that we can talk about here, and I hope we will be able to break down at least some of that, some of those pieces a little bit during this discussion. But I wanted to next go to some really, basic things. Clearly, the book is framed as a critique of a particular case, New York Times versus Sullivan. And as you mentioned, that case has become sort of iconic. The common wisdom on that case is that this was, championing freedom of speech and freedom of the press. It was a great step forward for those things. So I wonder if you could give us just sort of a brief summary of what is the conventional wisdom about Sullivan and why is it wrong?
Sure. And as I do that, maybe I should just say a little bit about the basics of the ruling so that our audience knows. So New York Times versus Sullivan is a landmark First Amendment ruling, I should say a freedom of speech and of the press ruling, more specifically, from 1964. And it also deals with the question of libel, and especially libel of public officials. And later they expand their test to include public figures as well. But what what the ruling says is that if you're a public official, in parentheses later a public figure, and you sue somebody for libel, that is defamatory publication about yourself, you're going to have to show not only that what was published about you was false and defamatory, which would have been a more traditional thing that you needed to show. You'll have to show that as well as that the thing was published with actual malice, which is mentioned in the title of the book. And you've used that expression already, Joe, too. So what does that mean, actual malice? It's a legal term of art that has a kind of a long history and has had different meanings. But what the Supreme Court meant by it in this case was you have to prove that the publisher of the defamatory matter either knew that it was false or published it with reckless disregard for its truth or falsity. It's a very high standard and a difficult standard to meet intentionally. And the court, in later opinions, admits that there may be worthy litigants who won't be able to recover damages on the basis of this principle. So I kind of simply say, by way of explaining this in the book and in other presentations, that it really sets up an unprecedented two-tiered libel system for Americans. If you're an ordinary person, you can sue under the traditional standards. If you're a public official or a public figure, you're going to have to jump over this much higher hurdle in order to defend your reputation and recover damages. So that's what it does, right? Now, what's the common narrative about it? I think the common narrative has been that this was a really great thing and necessary to protect freedom of speech and of the press from maybe meritless lawsuits that are brought by rich people or public officials who want to just avoid criticism. And for a long time, that was the conventional wisdom. And certainly it's only, as far as I know, in the last 10 or so years that kind of significant people have started questioning this ruling. It, I think, received probably a good deal of praise at the time that it was issued from the kind of First Amendment lawyers, as you would expect, right? And then, in other words, it didn't generate a lot of controversy at the time, the way other rulings have done that have later been revisited by the Supreme Court. But then over time, the journalists really love it. I think the appellate First Amendment lawyers really love it. They think it's a landmark ruling and that it really establishes for the modern period the proper protection for freedom of speech of the press. One other thing I'll mention about the reasoning in the court's opinion, which I know we may delve into more later. But one of the things that was concerning the justices on the court, it, and this is a term that wasn't used in the majority opinion, but was used in one of the concurring opinions, the chilling effect. The chilling effect has become a big deal in modern First Amendment jurisprudence. They want to interpret the liberty to publish what you want as broadly as possible, and I would say even more broadly than the founders had in mind, because they want to basically bend over backwards to make sure that nothing that should be protected is left vulnerable to any kind of meritless lawsuit or any other kind of improper regulation. So everybody thinks this is the right approach these days, or most everybody. That was the dominant opinion until just recently. Why is it wrong? I say it's wrong on a couple of counts. Um, One, of course, is the core originalist argument that I'm making in the book. I'm a believer in originalism or the quest for the original meaning of the Constitution as what really ought to bind judges when they are presuming to interpret the Constitution and to strike down laws or to strike down judgments by inferior courts. They need to be guided by the original meaning. And of course, some of your viewers or our listeners may know that in 1964 and in that period of time, the court was not famous for being bound by the original meaning. There are lots of cases that are regarded as landmark rulings now in which the justices of that era just seem utterly indifferent to original meaning. And they're pretty much interested in figuring out what they think is the proper policy balance and doing that. I would say, and we may have occasion to talk more about this, they're really doing what I regard as legislative or prudential reasoning, not judicial or legal reasoning. Now, that being said, there is a kind of, I would say, originalist fig leaf in New York Times versus Sullivan that I can talk about later if you want me to, but it's not a persuasive one. So if this goes back to what we were talking about a few minutes ago, it seems that the conservative legal movement's long quest, which has lasted many decades to kind of revive originalism as the reputable and correct approach to constitutional interpretation, is starting to bear fruit. And the court is showing itself willing to correct old rulings that were not really based on the original meaning of the Constitution. And so my book is kind of an invitation to them to do that. One other thing I'll mention though, like why is the narrative wrong? Um, I think what the narrative leaves out is a couple of things. One is that reputation is a right, properly understood, and a natural right, according to the founders. And so a modern test that leaves it so vulnerable is not deserving of all the praise that it gets when you don't take that into account. That's one thing. And the other thing I emphasize in the book is that everybody agrees that we need robust public debate in order to have functional self-government. People need to be able to voice their opinions and their thoughts, and that should be protected. But what the court did in New York Times versus Sullivan, in the name of that principle, is to create an immunity so secure for the press and anybody else who engages in speech and publication about public issues. It's so secure that they basically can get away with defamatory speech in many, many cases. And this is bad for our public discourse because it's what some of the older jurists would say is the public has an interest in knowing the truth and nothing else about their public officials. Otherwise, you're going to get a public discourse that's based upon all kinds of hysterical fears about half-baked theories or accusations that have never really been tested. I think it'd be better for our public discourse, the quality of our democratic deliberation, I should say, if there were more respect for and carefulness about telling only the truth. So that's my correction of the narrative, the standard narrative.
Okay, excellent. So there's a lot going on here, clearly, but just to unpack a little bit from some of what you've mentioned here, on the one hand, and this is more like the standard narrative, is that this is all about freedom of the press, freedom of speech, and that libel, as you explained, as people can sue over damage to their reputation, was perceived as basically a threat to freedom of speech. That
Hmm.
if you can sue newspapers and say, hey, you're saying bad stuff about me, then that kind of muzzles the newspapers or creates a chilling effect, like you were saying. and therefore it was a big advance for constitutional rights um, when the court decided, well, we're not going to completely ban that, but we're going to put very strict limits on that so that for certain classes of people, namely public figures, whatever that means, which we could get into, these people can't, sort of threaten, the press with lawsuits. They have to leave the press, free to criticize them, basically. But behind this is something which, some people may be more or less familiar with the technicalities of what libel is, but as you're saying, libel basically means that just like if somebody stole my property, I could sue them, or if somebody assaulted me, I could sue them for that, for the damages. If somebody's taking down my reputation, damaging my reputation, I can sue them over that. And this is
Hmm.
a traditional, this is, part of the English common law that was inherited into the American legal system, as you discuss in the book, and rooted in, as you mentioned, the concept that there's a right to reputation, that just like we have a right to physical safety, we have a right to the integrity of our reputation. Um, so there's a lot going on there, but I guess the point to start with is that this is pretty much left out of the usual narrative on this subject, right? That the Supreme Court is basically sweeping that under the rug and saying, well, we're not really going to be very concerned with the reputation rights of this certain category of people because we think we're going to advance public discourse by having this completely free and unrestricted, ability to criticize people in the media. And you're
Yeah, that's right.
suggesting that that's not only unfair to people's rights, but also is not necessarily good for public discourse either.
Right. And I would add, and I'm glad you reminded me of this, a big departure from the traditional understanding of these issues.
Hmm.
Um, the the way the court arrived at its conclusion in New York Times versus Sullivan was by thinking along these lines that you've been describing, that there's a tension between libel suits on the one hand and freedom of speech and of the press on the other hand. And on the basis of that tension, they work up this accommodation that they devise, which I've described and you've described too now, right? That well, in the case of public officials, we're going to have a separate standard that's very difficult to meet, but we won't go so far as to say that you can't sue for libel if you're a public official. That's all new, and it's based upon a wholly new way of thinking, I argue in the book, because the older, simpler, and I think more sound understanding simply was because reputation is a right, and because libel is understood as an unjust attack on that right, libelous publication is simply outside the scope of freedom of speech and of the press. If it's libelous, it's not protected by the First Amendment or other constitutional provisions in like state constitutions that protect freedom of the press. So that's another important way in which things change. The older understanding simply was these things are not protected because they're bad. We've heard other thinkers say things like, is it Abraham Lincoln who at one point says there is no right to do a wrong, right? Talking about another issue. Um, Justice Joseph Story, who was on the Supreme Court for a long time and wrote massive commentaries on the Constitution, which I draw on in the book, also wrote a little opinion in a libel case named Dexter versus Spear. And in the few paragraphs in that opinion, which is from the early 19th century, Story talks about this question of libel versus freedom of speech. And he's making a point, I think, of correcting the public and the litigants on this question. And he ends up saying, freedom of the press has nothing to do with this subject, right? In other words, if it's libelous, there's no freedom of speech question. So that was the older understanding that imposed a kind of stronger discipline. There's other categories traditionally, by the way, of unprotected speech, which I don't deal with in the book other than to mention them in passing. But yeah, I mean, in the old days too, things like obscenity and pornography were understood as being not protected speech. This is another area in which the Supreme Court has changed the traditional approach in order to protect things that would have been considered not worthy of protection, I think, by the founders and the generations that succeeded them.
Okay, excellent. So as you're implying there, both of these things that we're looking at, the idea of freedom of the press, for example, has a very long history to it within English and American law. And also libel, of course, as a protection, for reputation is something that has been there for a very long time. So the question about their relationship to each other, how do those things interrelate, is not at all new in 1964, right? That's
Right.
something that, as you're mentioning right now, has come up. And in your book, you give, I don't know how many examples from American history and going back looking at, Blackstone in the English background, many different examples of how the question has come up. And as you just indicated, the basic answer up until 1964, with some qualifications, was basically that these are basically two different things. In other words, the freedom of speech and the freedom of the press really has nothing to do with libel. And maybe you might want to dig into that a little more, but you just said a minute ago that basically, it's not the freedom to do wrong, right? So
Hmm.
the freedom of speech was never intended as a freedom to publish, say, like untruthful attacks
Hmm.
on somebody. And therefore,
Yeah.
if they can bring a successful case and say that this was libelous, then it isn't a protected uh, right on the part of whoever was publishing that. Is that
Right. And I
right,
think
or how would you?
yeah, that is right. And I think this makes a lot of sense from the standpoint of what I don't know, I'm repeating myself maybe, but moral common sense, right? Like we can think of other examples, and I may mention them in the book. I mean, everybody would have to agree on the basis of the text of the Constitution that people have a right to keep and bear arms. But if you accidentally shoot somebody with a gun, it will be actionable, right? I mean, they'll be able to sue you. And you wouldn't be able to say to them, well, because my right to have a gun is so important, you'll have to show that I had actual malice when I shot you. I did it deliberately or I did it with extreme recklessness. No, if you
Mhm.
did it even with minimal carelessness, it's going to be assumed that it's your fault. Or again, we have a right to free exercise of religion. So you'd have a right to get together with others and build a church or something like that. But if in the course of doing it, you damage nearby property of somebody else, they're going to have a right to sue you, and it won't matter that you were exercising a right to religious freedom because you don't have a right to use that right in such a way as to injure somebody else. And actually, in his commentaries on the Constitution, Justice Story does cite this ancient adage, use your rights in such a way as not to injure the rights of others, or use your freedom in such a
Mhm.
way as not to injure the rights of others. And this was the common understanding for a long time. You mentioned Blackstone. Blackstone says it in his commentaries on English law, the English common law, that where libels are punished under English law, freedom of the press is by no means infringed. So he treats it as a wholly separate category. The early American commentators and cases that I cite in the book also do the same. And then it carries forward really till almost the eve of New York Times versus Sullivan, which is why I think you can tell that that ruling is a big innovation. 1940s, there's a famous case. It's often taught. I've taught it many times in con law classes. Chaplinsky versus New Hampshire, which is a little bit different. It's a fighting words case because the guy says some inflammatory things in public. But along the way, in dealing with that, the court, I think it's Justice Murphy wrote the court's opinion in that case. He just says it's been cited so many times. In passing, he says, well, it's well understood and established that there are certain categories of expression that are not thought worthy of the protection of the First Amendment. These include obscenity, libel, defamation, fighting words. And then, and I like to point this one out because it's so striking, in Roth versus United States, which is a late 1950s obscenity case, the court says it again that, well, everybody knows libel's not protected by the First Amendment. That's one of those categories. I like to point that one out because that opinion was written by the recently appointed Justice William J. Brennan. So even a few years before New York Times versus Sullivan, which Brennan wrote for the court, he was kind of reiterating the traditional wisdom that libel is just not protected by the First Amendment. So we don't have to twist ourselves into all these knots to create these exceptions and protections that just weren't thought to be there.
Mm.
Now I know that I'm kind of pushing against a modern prejudice on this because most people think today, I believe, that they just have a right to say whatever they want to, about public officials because that's part of freedom of speech and of the press. But as I think the evidence in the book shows, that's not the traditional understanding. That's really an innovation coming out of the 1960s. I mean, there have been people along the way who have argued for things like that, and I mentioned some of them in the book as well. But that was never really the majority position. That was really never the law. And generally speaking, and I try to be careful to document this in the book, when you find in the 19th century litigants kind of drifting in the direction of something like the New York Times versus Sullivan Standard, saying like, well, we're a newspaper, you have to cut us some extra slack because we're publishing about public issues or public figures. That argument does get raised from time to time, even in the early 19th century. But what you see happening every single time that it's raised is that the judge who's responsible for the case will just kind of say, yeah, well, that's not the law, right? That's not what is the actual legal standard. So it's an error to think that that should be the way to go.
Yeah, I found that so striking in reading the book that this has, come up in the arguments that the court's using in the 1960s had come up in various guises over, the decades and centuries, but they had been shot down over and over again, and sometimes in very stark terms. Some of those judges that you're talking about will
Hmm.
go on to give the rationale for it as well,
Yeah.
as to
Yeah.
why that's not really, respectful of personal rights and not
Mhm.
really beneficial for the community to neglect that. So
Yeah.
yeah, I found it, that's just an example of what I found to be so, fascinating about this book is just to start, with this one case and look at how many, doors that opens into looking at the history of these concepts. Um, yeah, so, one thing I thought we could uh, go back to for a minute is the emphasis that you place on originalism. You mentioned this
Hmm.
a few minutes ago, but I wonder if you could explain to the audience a little bit how would you define originalism and why do you think that it's so important to take an originalist approach? And the court is tending to do that now. So why is this so significant?
It's very important, and I don't spend as much time on it in the book as I might have done because it's an originalist inquiry. So to some extent, and originalism is now a reputable and sort of established mode of interpretation. So I didn't want to spend a lot of time defending it, but it does really need defending in other works because it does remain controversial. Originalism is the idea that the Constitution should be interpreted according to its original meaning. We find justices on the court today, like Justice Thomas writing for the court, I think in some of the Second Amendment cases, saying that the proper understanding is that the meaning of the Constitution was fixed at the time that it was ratified. So the understanding is that the Constitution has a permanent meaning. It doesn't evolve. It's not a living Constitution. As far as judges are concerned, it may be a living Constitution in the sense that you can ratify amendments to it or that some practices may change that are informal. But when you're asking judges to interpret the meaning of a constitutional provision, the idea is they are duty bound to seek the original meaning of it. Um, One misconception about originalism that I think is very important to refute is that it's just a modern invention of conservative justices and conservative lawyers who want to justify the outcomes that they want. That's a kind of typical, I would say, liberal talking point against originalism. I think the more sophisticated students of constitutional law know that's not true. It is true that the court in the 60s and 70s became very uninterested in original meaning, and that provoked a response on the part of the conservative legal movement that tried to restore or resurrect originalism. But that doesn't mean that they were just inventing it as a mode of interpretation. I would argue, and I know there are some scholars that disagree with this, but I really think they're wrong. I think if you go back and study the way the founders expected that the judicial power would be used, you can tell that they were doing originalism, even though they didn't use that term. I think the great opinions by Chief Justice John Marshall in his era are, for the most part, originalist inquiries into the text, the structure, and the original meaning of the Constitution. One that I mentioned in the book which is a short little masterpiece, not my book, but this opinion um, by Chief Justice Marshall is in Barron versus Baltimore. That's only about 3 pages long, but it's a great kind of model of constitutional inquiry where he starts with the text, talks about the general nature of the Constitution or its general purposes. And then he turns to the history of the day when it was ratified. So it's pretty clear that he's thinking that whatever they were thinking at the time the Constitution was ratified is what should inform our interpretation of the specific provisions. Um, so I think, and even I've written other things, by the way, about the debates in the Washington administration between Hamilton and Jefferson about the scope of the necessary and proper clause and things like that. Even that early on in the 1790s, I think if you look at those arguments, they're seeking the original meaning of the Constitution. And, this goes, where does this come from? One might ask. And then I'll say one other thing about why I think it's important to answer your question. It comes from just the standard normal approach to statutory interpretation that would have prevailed in the English and American world at the time. If you're dealing with any law and you're a judge and you're not the lawgiver, your job is to try to find out what was the intention of the lawgiver. What did they mean when they wrote that law? And then, since the Constitution is understood to be a form of written law, superior in obligation to other laws, it just gets adapted as a standard method of interpretation to apply originalism to questions of constitutional interpretation. Now, why is this all important? I guess I could sum it up in two ways. One is I do think originalism is the original traditional American approach to constitutional interpretation. I mean, if somebody wanted to do it, I would not recommend it. But if some society wanted to just give judges a kind of freewheeling power to use their own moral judgment about issues of public importance, you could do that. But we don't have that system. Nobody along the line until very recently thought that judges were entrusted with that kind of discretion. So, as a conservative myself, I have a preference for the traditional way of doing things. But then the other argument that's often made in defense of originalism is, of course, it is the one way of making sure that judges are not just making up the law, but are actually discerning the law. When you there's another approach that's kind of popularly considered, I guess, living constitutionalism, and some justices have even defended this. Justice William Brennan did in his speech on so-called contemporary ratification, where they say that, well, we're seeking the contemporary meaning of these things. What does the contemporary public think about the meaning of, say, due process of law or freedom of speech or what have you? But of course, it's very easy for judges to conflate what they think with what the contemporary public thinks. It's very commonplace for any of us to say, like, well, everybody knows such and such, when in fact it turns out that you and your circle of friends, quote unquote, know this, but it's not what everybody thinks. So, yeah, I think originalism is very important to the discipline of judging, making sure that judges are interpreting law and not inventing law.
Excellent. Yeah. So would you agree that part of what's in there would be just maybe the separation of powers itself, right? That we have chosen to give lawmaking power, to Congress. And as far as the Constitution goes, it was, the ratification process and the amendment process is how we've
Mhm.
chosen to actually change when we want to update the Constitution. So that's kind of baked into our Constitution that we didn't ask judges to do that, right?
Right. And I think that was understood quite well early on because if I can go back to one of my favorites, Chief Justice Marshall, there are passages, which I do mention in the book, in cases like McCulloch versus Maryland, where he says for the court to kind of weigh questions of degree is to tread on legislative ground and improper, right? So he clearly has the idea that when you're kind of balancing different goods and kind of figuring out what is the proper way to accommodate them all, that's a form of prudential or legislative reasoning that belongs to the lawmaking body. It's for them to do that. Our job as judges, Marshall seems to be suggesting, is just figure out what the law means. And once you figure out what it means, you're bound by that. And
Mhm.
it's not really up to you to make your own substantive decisions about the common good and impose them in the case. You're supposed to be guided by the substantive opinions about the common good that are embodied in the written law that you have at your disposal.
Mhm. Yeah, yeah. I mean, if you think about the concept of the rule of law, we frequently distinguish between the rule of law and the rule of man, you know.
Hmm.
So if there's any situation where some individual can just kind of make up the laws that are going along, that isn't the rule of law, right?
Hmm.
So by separating law between legislatures and, and judges, we kind of prevent that. We're intending to prevent that from happening. Nobody gets to
That's
just
right.
make up the law on the spur of the moment based on looking at the parties and whether they agree with one party or the other or something like that, right?
Right.
Yeah, so it seems like in and of itself, there's a lot at stake with originalism. It's not just a question of do we like the outcome or not, or is this going to produce the best, outcomes? Because hypothetically, originalism might produce outcomes that we really don't like, in which case the response would be what? Let's amend the Constitution then, right?
That's right.
That would be respectful of that division of labor, that separation of powers, and things like that, and the rule of law, to say that if we've decided that this is no longer a good outcome, we're going to officially declare that so that everybody's on notice about that rather than finding out after the lawsuit, after they're in the middle of
Right.
the lawsuit, that that used to be the rule, but now we have a new rule all of a sudden. Okay, we are back. We were briefly cut off there, but we had just looked at what originalism is and some of the basic reasons why, in of itself, it's important to approach things from an originalist point of view. But one other question that I would have about originalism is that sometimes a problem or a challenge is posed to it, especially in terms of, say, like following the text of the Constitution. What if something is not
Hmm.
mentioned in the text of the Constitution, or the language is pretty broad? Then the argument would be, well, then we can't really know the original meaning. There's not enough information. In this case, libel is not mentioned per se in the Constitution. So if we're wrestling with this question of what is freedom of the press, what is freedom of speech, how does it relate to libel, how do we know that we're following an originalist view of those things if it's not explicitly mentioned? Where are we going to look? And what kind of dots do we need to connect within the legal system to make that judgment?
That's a very important question and an interesting one. Obviously, there are some cases that would be quite easy, and this could build a little bit on what we were talking about earlier. The Constitution makes clear that the president will serve a 4-year term. You could think that that's crazy and terrible, and it'd be a lot better if it were 6 years, but it's very clear the Constitution does not say that. And so until you amend, you'll have to be bound by the 4-year term. Um, there are other passages that use terms that are not so clear cut as 4 years, right? And so then the question is, where do you turn? And sometimes people will suggest, as you said, that it just seems like there would be no answer to that. I think in many cases there is a much clearer answer that you get from delving into the materials than you would have thought. Um, I'll come back to our main example in a minute, but I like to think of others as well, just to illustrate. Um, Another part of the First Amendment says Congress shall not make no law respecting an establishment of religion. That's been interpreted in a certain way in modern times that I also think is different from the way the founders would have interpreted it. The modern courts have suggested that anything that promotes religion in any way is an establishment of religion. But I think if you look at the founding, they had a narrower understanding of what a religious establishment was. It was some kind of official church with penalties for people who didn't um, get on board with the official theology and things like that. It's even the case, by the way, with very general expressions like due process of law. There's a long history of what that actually means, like to be deprived of something by by the law of the land and not just by anybody's discretion, any kind of executive official's arbitrary discretion. Um, and the same thing is true, I would say, and I do argue in the book, with regard to freedom of speech and of the press. That's a very general expression, and the text alone doesn't tell you what you need to know about the issues I'm dealing with in the book because it doesn't require an actual malice standard, but then neither does it require the kind of standard that I've talked about in the book. So I think you need to look at, and I'm not the only one to say this, this was said by the court these days, as well as by people around the time of the founding, that a lot of the concepts used in the Constitution, especially ones that pertain to rights and liberties, have a common law meaning, and you would want to look to the traditions of the common law to figure out, or to get into the ballpark anyway, as to what these things mean. I don't necessarily want to be bound by exactly the common law understanding of freedom of speech and of the press, because I do think the founders had a more permissive understanding in mind than what Blackstone had in mind. And we could talk about those differences, but it is, leaving that aside, and we can discuss that later if you want to, it's pretty clear that if you look at the debate over the Constitution, if you look at the way the Constitution is written, the assumption seems to be that freedom of the press is an already understood concept. I say a little bit about this in the book, that when the Anti-Federalists argued against the Constitution because it omitted any protection for freedom of speech and of the press, they weren't acting like they had some new great concept that no one had thought of. They were treating it like a traditional concept that had been improperly omitted from the Constitution. So the discourse itself suggests that there's already an understood meaning to that expression. And the way to find it would be, and I'm not the only one to say this, guys like Justice Story and others say, well, you'd have to look at the English common law, what was meant by freedom of speech and of the press, and go from there. Um, Also investigate the American kind of modifications of it. But I think that's how you have to fill these things in, is to look at the broader historical legal context of the time.
Okay, excellent. So we were talking about common law, and just for the audience here, we're talking about really a set of precedents that goes back to what, the 1200s in England, that
Hmm.
has come down with all kinds of decisions and precedents and treatises, like Blackstone being one of the more famous, kind of
Hmm.
summarizing all these things and the
Yeah.
principles of law that come out of that. And so when the Constitution is talking about things like the freedom of the press, or one example that I like to look at is a trial by jury, because that comes up twice in the main text of the Constitution, and then in the Bill of Rights, there's a guarantee of a trial by jury, but the Constitution doesn't tell us what a jury is. It doesn't
Hmm.
explain what that means, right? Because it's
Yeah.
not making up a right to a trial by jury. It's not establishing a right to a trial by jury. That already exists, and we already know what that means. They're just promising not to get rid of it, or not to
Hmm.
infringe it, or giving it added, constitutional protection. That's
Yeah.
not going to, the Constitution is guaranteeing that the existing freedom of the press, the existing trial by jury, is not going to be changed in the future, according to whatever those parameters are. So I think that, in itself is a really important concept to, think about, is
Hmm.
that mentioning something in the Constitution doesn't mean we're inventing this or we're establishing it now. As you said, like with the anti-federalists, they weren't saying, "Hey, we need to come up with some, some
Uh,
things." They were saying, "We just want an explicit guarantee that we're not going to lose these
mhm.
things that are there." Um, and so, yeah, there's obviously, you mentioned, that it's not a static thing. The common law, um, has itself, evolved over the centuries, and within the American tradition, there were some different interpretations of something like, the freedom of the press. I understand with libel, and you can correct me if I'm mangling this a little bit, but with libel, for example, that in the traditional English common law, um, I don't know if this only applied to criticizing the government, but even if I could prove that my criticism was true, it did not make me innocent of that seditious libel. In fact, it might
Hmm.
compound it, because exposing true faults would be more damaging, to the government.
Hmm.
But then early on, even before our Constitution, just during the colonial period in America, there was a kind of a consensus that emerged that if I'm publishing the truth, I should be free to do that. So truth,
Hmm.
in other words, should be a defense against libel.
Hmm. That's right. And in the English common law, that applied not only to seditious libel, but to any criminal libel. Because
Okay.
as Blackstone said, the law regards the potential breach of peace in criminal libel and not so much the protection for reputation. Civil libel protects reputation, but the criminal libel laws, Blackstone thought, were mainly intended to prevent the breach of peace that might follow when you expose something humiliating about somebody, whether it's true or false. It could lead to fighting, right?
Hmm.
Especially in a culture where there's a history of that kind of thing. So the founders took a different view and they thought it was proper. The great Alexander Hamilton argued for this in People versus Crosswell, which is an early case that I talk about, thought it was very important that truth should be a defense even against a criminal libel charge. Although the traditional understanding is kept to this extent, truth is treated by them, the Americans of the early period, as a conditional defense, right? Not an absolute defense. So they still retain the view that there are some forms of exposure of truth that could be malignant in their character and not really deserve to be protected. If you're
Hmm.
exposing somebody's dirty laundry just to humiliate them, you still might be in trouble according to those standards.
Yeah, I remember there's a formula that comes up in your book several times. I couldn't quote it, verbatim, but it seems to sort of outline, in a sense, the positive, duty that's imposed on if you're a newspaper, you're a reporter, you're a media, basically, what should you
Hmm.
be doing to vet what you're publishing? And part of it, of course, is that you should be aiming at publishing the truth. You should be seriously investigating to make assure the truth of what you're saying. But another part of it is you should have good motives.
Yep.
So that's what you're saying. Even if something is true, but it's clear that the only reason for publishing it is to hurt somebody, and there's really no
Hmm.
legitimate need to publish this, then that could also be grounds for being
Yeah.
found guilty, because the positive duty is that you should be publishing what's true and what is beneficial for the public good,
Hmm.
something to
Right.
that
The
effect.
expression, it's a great one, and it became a standard one. I don't know if Hamilton originated it, but he did use it in People versus Crosswell, and then others. As a much later justice said, Justice Robert Jackson, I think in Boharnis versus Illinois, said it became the common sense of American criminal libel law. The expression is the right to publish truth with good motives and for justifiable ends.
Yeah,
So,
that's what I was thinking of there, that formula. I found it was such a beautiful formula because I think to me it helps to connect all the different pieces in terms of what's at stake in
yeah.
both the rights that are at stake, but also the public good.
Hmm.
That if we're trying to promote, a free and constructive public debate on things, we should at least be able to regulate ourselves by that standard that I'm
Hmm.
going to say what I believe is, and not only what I happen to believe is true, but what I've done due diligence to confirm that it's
Yeah.
true, and
Right.
that I have just motives for saying this. I'm trying to promote some common good with what I'm saying rather than simply, you know, finding a loophole to try to get revenge on somebody or
Yeah.
hurt somebody for whatever reason.
Yeah, I've thought about that a lot as I was writing the book and as I've talked about it with different people. But the example I think of, or like a hypothetical example that I think of that helps us to kind of interrogate our assumption that you just always have a right to tell the truth, right? Because it sounds like the Hamiltonian and founding approach to this would be unduly restrictive because surely you always have a right to tell the truth. So the example that I would give, again, hypothetically, would be if somebody's running for governor and it comes to your attention that this candidate had like an extramarital adulterous affair 15 or 20 years ago, could you publish that with good motives and justifiable ends? Very possibly, because it speaks to their character, right? But if you find out that just Joe Blow next door had an extramarital affair 20 or 25 years ago, could you publish that in the newspaper with good motives and justifiable ends? I mean, probably not, because then you're just doing it to gratify somebody's salacious interest in human misdoing, or maybe just to hurt that person and embarrass them. There's a beautiful expression, by the way, in one of the early cases, and I don't remember if this made it into the book or not, but some judge commenting on this in the early American period said, people who publish things like this ought to be asking themselves, why are they publishing something that, for all we know, was overlooked or forgiven by the people directly involved, right? You don't have to expose everybody's misdoing to the public eye. And we could go back to a very general but very important moral principle, which we've all heard, which is, do unto others as you would have them do unto you. I don't want everything bad I've ever done published in the newspaper. Nobody should want that. So there has
Mhm.
to be some serious reason for it. As you said, some bearing upon the public good to publish negative things about people.
Wow. Yeah, I mean, I'm tempted to get into the world that we live in right now and just the how the experience that we seem to be moving towards that kind of situation where whether you like it or not, everything's going to be on the public record.
Hmm.
But it's yeah, I did find this to be an inspiring aspect of the book to just kind of think about what we should really be aiming at with public discourse.
Hmm.
Aiming at an environment where, yes, we can hold each other accountable and we can criticize, people when justified, but also where there's a kind of, humanity and grace and forgiveness and respect. There's sense of respect. Just because I have criticisms of somebody doesn't mean that they're subhuman. They don't have basic
Hmm.
rights. Because that does, to me, that's one of the implications that I thought about was just the sort of dehumanizing side effects of a
Hmm.
completely, an apparently unregulated kind of public discourse where everybody just says whatever they want to say about anybody else. That we can easily forget that we're dealing with human beings.
Yeah, I think that's right.
But interestingly, part of what you said a moment ago seemed to suggest that even in these traditional standards, there could be certain ways in which being a public figure could change the equation somewhat in a lawsuit.
Mhm.
So, for
That's
example,
right.
it could provide a rationale for why the newspaper had to publish something about so and so because he's running for office, as opposed to if they did it for somebody else, then that would just be malicious.
Hmm. That's right. And it is the case that at the time of the founding and thereafter, there were ways in which their thinking did accommodate differences in approach between public, but they don't really use the terms public figure, but they'll talk about candidates for public office or persons in a position of public trust or candidates for such an office. Um, And so they do treat them differently. They don't treat them differently in the way the New York Times versus
Yeah.
Sullivan opinion does, where, Sullivan opinion is admitting that the thing in question is false and defamatory, and then setting up a different way to handle that. They don't do that. If it's false and defamatory, they tend to treat it as just outside the scope. But if something is true but hurtful to reputation, the standards that prevailed at the time of the founding would have said that you can give someone more running room for a truth defense if the person in question is a public official or someone who is a candidate for public trust. Because, as Chancellor James Kent of New York explains, in those cases, there's a much better chance that you can show that you published with good motives and for justifiable ends because the public might have some need to know this or some right to know it.
Hmm.
So that's basically the difference. We give you more scope for a truth defense if the person who's been the target of the accusation is a public person.
Yeah. And I think another useful thing to look at for a minute might be if we were just to sort of formulate, the status quo as a result of Sullivan, if you're, the press, right now, and you're going about, publishing, critical pieces, in effect, what kind of scope are you being given? Would it be correct to say that basically right now, if I'm, a member of the press, I can, I think you might even suggest at one point in the book, there could even be sort of a perverse incentive that rather than investigating whether what I'm saying is true, it might be in my own interest to just not even investigate it because that way I can use it as an excuse in the courtroom if necessary of, oh, gee, I didn't realize it was false and I didn't bother checking.
Mhm.
But the standard is so low basically that you can get away unless they can prove that you knew it was false and that
Right.
you deliberately published falsehoods, then you can use almost any excuse to say, gee, well, it turned out to be false, but I just didn't realize that.
Yeah, I mean, it is the case that the more you investigate, the more you create a possible record demonstrating actual malice. And the actual
Mm,
malice test won't punish you for mere careless or won't hold you to account for mere carelessness or negligence. Justice Brennan makes that clear in some of the follow-on cases that the actual malice standard is actually very different from a negligence standard or a quote unquote like reasonable man standard, what a reasonable and prudent person would publish. Those are not protective enough, according to him. So when you take that in connection with what he does think is protective enough, it's fair to say that the actual malice standard gives you a kind of immunity to be careless
hmm
or to publish things that a prudent and reasonable man wouldn't publish, as long as you don't go so far as to the degree of actual malice.
Okay. So it's setting the bar at the point where it's okay to be negligent, basically, in
Yeah.
in reporting things. All right. Well, there's so many details that we could get into and fascinating, little angles that we could look at. But to sort of wrap things up, the last thing I wanted to bring up, going back to some of the different threads that we talked about, an originalist approach to interpreting the Constitution, how this was not really guiding the court in 64, and you're arguing that it should guide a reconsideration of this. And we talked about why that's important itself, but also some of the different sources that are available for following through with that kind of analysis and what they have to say. And a lot of what they're talking about is, really a different perspective on the rights of human beings and on the public good. And so my final question is it simply a coincidence that an originalist approach is going to lead us, back to some different moral and political, considerations? Or is there any specific reason why we could expect an originalist approach in general is going to lead us maybe to, consider some more profound, moral and political arguments?
Hmm. Yeah, I think it's not a coincidence. And I would add, just by way of preface, that this is a very important consideration, but that is also maybe not necessary to defend originalism. I mean, in other words, if you're a principled adherent of originalism, it might be that the original meaning is binding on you, even if it represents some moral error, right? Because if you're the judge, you're just not allowed to make up the correct answer and pretend that's what the law means. But clarifying that just for the sake of theory, I think in general, it's not surprising and not a coincidence that the originalist reading is more congruent with the common good because I tend to think that the founders and the founding generation had a more robust understanding of the common good than we tend to have today. And we can't get into this entirely, and I haven't thought about it enough in preparation for this interview, but I know that you and I are both interested in de Tocqueville and his account of modern democracy. And we know from de Tocqueville, I think he's correct, that the spirit of equality tends to wash out a people's commitment to its own moral traditions and tends to foster greater and greater individualism where people don't have as much commitment to the common good. And over time, those things can be a big problem. And it's our job as people who want to, if we're following Tocqueville, maintain the conditions necessary for human freedom and human dignity under modern democratic regimes. We have to be mindful of the older wisdom about human nature and the human condition that was built up over many millennia and that was still appreciated at the time of the founding. Whatever, whether we go with Tocqueville or somebody else, it just seems to me that there is a very kind of libertarian and egalitarian drift in our civilization that's happened since the time of the founding that the founders would not have agreed with if you interrogated them and looked at all of their moral opinions besides just the ones that are famously, say, expressed in the Declaration of Independence or something like that. So, to come back to some of the things we've talked about, with their understanding of freedom of speech and the press in relation to libel, to obscenity, they seem to have understood that like scurrilous pornographic materials are bad for the human person. They seem to have understood that there is a right to reputation and not just an interest in reputation, which seems to be connected to their understanding that human beings are by nature moral and sociable beings, and that those kinds of concerns are not just artificial creations of calculating reason to allow us to live together, but they're part of the natural law by which we can live together in a dignified and humane way. Um, so, yeah, I mean, we want to live in a society in which individual rights are respected, but the tendency over the last couple of generations has been to inflate them at the expense of the common good. I think the founders thought both of these things are very important, and they had a more balanced appreciation for how rights fit into the common good. So, not, the founding was not perfect. The founders weren't correct about every single thing, but I'm more comfortable with their overall moral universe than with some of the things that have happened more recently.
Yeah, yeah, I think it's a great answer. And you mentioned the natural law there. I would point out that if you look at Blackstone, he, considers natural law rooted in eternal principles, principles that really reflect the mind of God, basically,
Yeah.
and that these are the foundation of English common law. And
Hmm.
of course, it doesn't mean that the details, the specifics are all coming straight from God, right? It's more that it's a process by which that's known to be sort of the foundation. So everybody who's involved is trying to go back to that foundation as they work through the specifics. We see that in the Declaration of Independence, that again, it's
Hmm.
responding to the particular circumstances of the British Empire, but it's trying to root that in a conscious understanding of the laws of nature. And I think in your book, it was echoed at least by, say, like Alexander Hamilton, if not some others, perhaps, who use language that I think is very resonant with, like the eternal principles and things like that.
Yeah.
So when we're talking about the right to reputation, right, we're not talking about something that is simply a preference that some societies have or some,
Hmm.
groups of people have, but we're talking about something that is part of the design
Hmm.
of human nature and human society. Um, and so the linkage between, say, like rights and the common good that you're talking about is clearly problematic in many practical situations. But if there's some kind of fundamental bedrock set of principles that includes rights and the common good, then
Hmm.
we have a resource, is I guess the way that I would think of it. And to me, that really looms pretty large in reading your book, because if you were to compare this to, say, like Oliver Holmes and this whole strain of jurisprudence that came out of there, it very explicitly rejects natural law as having any possible relevance to the interpretation of law. And what I find fascinating about this is that we don't necessarily jump from, hey, like the First Amendment to natural law. We're just going to use natural law to interpret it. But if we're probing into, well, what did this mean in the context, and how does this relate to the precedents in the common law and the public debates and all these things that are happening, then uh, all of those people in all those circumstances are in fact looking to a particular foundation, which today is, and I know that's a whole different topic, but today is really not an accepted part of the discourse in the legal community, you might say. So
Yeah.
that aside, I mean, there's no question, I think, that, as you have noted, originalism is sort of having its day right now, and that you've done a tremendous, service, both to the public, for taking this important issue and just giving it an incredibly thorough analysis. But also, let's hope even those on the court who are going to have to be considering this and similar type issues in the future, that they'll be looking at your work here and following a similar path.
I hope so.
Well, Carson, we could go on forever, but I want to thank you so much for being with us today, and I do hope we'll be able to do again sometime in the future.
All right. Thanks. I'd really love it, Joe.
Thanks, Carson.